Mr. Black, we're very sorry we're late. Blame Lord Sumption.
That was said with my permission.
Causation and loss, my lord. I hope to begin with some propositions of law that I believe are uncontroversial. First of all, we'd say that in a straightforward case of breach of contract, the burden is upon the plaintiff to prove his loss, and that where that loss depends upon the actions of the plaintiff himself, he must show what he is likely to have done had the breach not occurred. And we find the authority for that in the Allied Maples case. If you'd be kind enough within the core bundle to go to page 2830, there is, I think, an authorities core bundle.
Oh, I see.
Yes.
It's in volume 1 of the authorities core bundle.
Oh, I see. Very well.
64.
Sorry, can I have that page again, please?
It's 2830. It's tab 64. And the passage that I'd like to direct the board's attention to is next to letter G, then on page 1610 of the report. Although the question is a hypothetical one, it is well established that the plaintiff must prove, on balance of probability, that he would have taken action to obtain the benefit to avoid the risk. So we concede that, and indeed that, I think, is very much the proposition that my learner friends looked to. They gave us a couple of additional authorities on Friday, and one of which is the Morris, Garner and One-Step case. I don't know whether they found them their way into the board's bundles.
Do you want to refer to it
I
now
would like,
or in reply?
Well, my lord, may I just give the reference? I suspect my learned friend is going to take you to these paragraphs in any event, but it would be paragraph 96, subparagraph 6, 7, and 8, particularly 7.
Sorry, of which case?
This is of the Morris, Garner, and One-Step case.
Yeah.
That was an additional authority of my learner friends. It's on page 33, and I strongly suspect you're going to hear from my learner friend on that in any event. But that is very much up for the authority for the same proposition. Secondly, where the loss depends on the discretionary actions of the defendant, the court must take a reasoned analysis of how the defendant would have acted had he not been in breach. And I should like to take you to the BMI baby case, which you'll find in Authorities Bundle 2, at tab 75.
Page?
Page 3218. This is the judgment of Lord Justice Toulson, and my lords may be familiar with the case. This is the case about the operation of one or two aeroplanes from an airport and what was the minimum performance, standard of performance recognised. And so the court was looking at how one assesses damages where there is a degree of discretion in the performance by the defendant. And Lord Justice Toulson looked at the well-known case of Abrahams and Herbert Reich about the publication of a book which, as he said, was distinguished by the composition of the court. Could I read from paragraph 121, please, internal page 768 of the report? The leading authority...
How far are you going to read?
I'm sorry, Mark.
How far are you going to read down?
Just that paragraph.
Just that. Shall we read it to ourselves?
If you would, and then I have essentially two other paragraphs that.
Let's read it first. Yes, and where are the two other paragraphs?
Page 127, which is internal page 769, bundle page 3219.
Yeah.
And then the next paragraph is paragraph 141, which is bundle page 3222, internal page 772. 3222.
I'm so sorry, it's my fault. Paragraph number.
Oh, paragraph 144.
Thank you very much. Got it.
Right, well, we'll read that one now. Yes, I think we've read that now.
Thank you, my lord. The third proposition I should like to make is that where the loss is dependent upon the actions of a third party, the court will approach the assessment of damages on the loss of a chance basis. And that will be on a percentage basis. And that is the Allied Maples case, followed most recently in the case of McGill. I don't intend to take the board to it. It's a
We're not in that area on the
principle.
facts. We're not in that area on the facts.
We're not. That's why I'm not taking the board to it, my lord. But I think it was floated as a possibility, perhaps in our case, that a percentage, and I don't pursue that. On a further analysis, I accept that it is only apposite where one is depending upon the actions of a third party, that we're really in the preceding situation where the court has to make the sort of analysis that Lord Justice Toulson was talking about in the BMI Baby case, looking at all the commercial realities and circumstances.
So long as the contract doesn't provide for a minimum level of performance, in which case you're back to Laverack.
Yes, exactly, because that's the alternative.
Yep.
Exactly, my lord. The next case I think we will spend a little more time upon, which is the Smith-Newcourt case, authorities bundle 4 at tab 102.
Page?
Can you give me a page?
Yes, I'm going to begin at page 4016.
Thank you.
That's electronic 4016. But again, a very well-known case. I'm sure the board recollects. This is the case of the Ferranti shares, where the House of Lords had to consider what was the proper measure of damage in relation to the sale or the purchase of shares induced by fraud, where the shares themselves had also had their value reduced by an earlier fraud. And so particularly, I will be taking you to the speeches of Lord Brown-Wilkinson and Lord Steyn when they look at how one assesses damages in those cases, but they make more general observations that I will submit apposite in the present case.
Very well.
So if I might begin just starting with the basic proposition, where the loss is consequent on the purchase of shares by reason
Where are you reading from?
Well, my lord, the proposition that
It's your proposition.
my proposition
Yes.
is that in a case of the purchase of shares, the usual measure of loss is the purchase price less their actual value at the time of acquisition. And the page that I went to on page 4016, next to letter A, in the speech of Lord Steyn, he says that's the normal method. But generally the date of transaction would be a practical and a just date to adopt. It is not always so. It is only the prima facie right date. It may be appropriate to select another date. And so that was held not to be an invariable rule, and it may be appropriate in a particular case, for example, where the market at the time was inflated by the same misrepresentation, to take a different measure. And if I could ask you to turn on earlier in the report to electronic page 3993, and the speech of Lord Brown-Wilkinson, which is internal page 261 of the report, between letters F and G, he says it was common ground that there was one exception to the general rule where the open market at the transaction date was a false market in the sense that the price was inflated because of a misrepresentation made to the market generally by the defendant, emphasized. The market value is not decisive. In such circumstances, the true value at the transaction date is to be ascertained, but with hindsight. Equally, and now this becomes perhaps more relevant for present purposes, if I can take you to page 3999, again in the speech of Lord Brown-Wilkinson, internal page 267, he also held that normal measure will not normally apply where A, the misrepresentation has continued to operate after the date of acquisition of the asset, so as to induce the plaintiff to retain the asset. And I'll come back to the significance of that when I've just finished going through the case, if I may, my lords. On the other hand, the House of Lords recognised that where the asset has depreciated through reasons not associated with the fraud, as Lord Brown-Wilkinson on the same page put it, that is a difficult case, just above letter H. This is not a case of the difficult kind that can arise where the depreciation of the asset acquired between the date of acquisition and the date of realisation may be due to factors affecting the market which have occurred after the date of the defendant's fraud. And may I also take you on the same theme to what Lord Stayne said at paragraph 4017, where he says, that's internal page 285 of the report at letter G, the position would have been different if the loss suffered by Smith arose from a subsequent fraud. That would be a case like the misrepresented horse in Chief Justice Coburn's example in Twycross and Grant, where the buyer plainly cannot recover the entire value of the horse if it subsequently catches a disease and dies. So drawing those strands together into my argument, we submit that the House of Lords recognise the possibility of cases where a party is induced to retain an asset by fraud, and where the asset is impaired subsequently to that fraud. We submit that this present case is a case of retaining shares by reason of the fraudulent misrepresentations that we have endeavoured to show to the board before the short adjournment. We submit that the fraudulent misrepresentations induced Mr. Al-Sadik to refrain from exercising his rights.
Is that something that you have to prove as a matter of fact? i.e. that he was caused to act in that way?
My lord, there was evidence which was not considered by the judge as to what he would have done had he been aware of the situation.
Well, the judge must implicitly have rejected it, surely.
No, he made no finding on it.
But the judge found that what would actually have happened would have been that it would have been invested at greater loss. Now, that finding seems to imply a rejection of any evidence that something different would have happened.
My lord,
you're coming to this, maybe.
I am, but my lord, I can deal with it now. I mean, we say that the judge's finding was wholly incomplete as a matter of law. Yet all he did find was that if Investcorp did not invest through Blossom it would have invested in SMFCO times, in DSF, LDSF times 3 and SMFCO times 2, I think.
So that suggests that the judge did not accept that the whole thing would have come to an end because the judge would have, because your client would have simply withdrawn his instruction.
Well, he didn't go on to make any findings about that. Plus, he also said...
But he must have rejected it because his view as to what would have happened is inconsistent with it.
My lord, all he said was that would have been the investment.
Well, he may not have analysed what the alternatives would have been, but he must have concluded that the contract would have gone ahead on that different basis.
Well, my lord, the evidence upon which he based which was on his own judgment an incomplete analysis, because he says at one point, I find that there'd be no loss, but then later in his judgment he said, well, I'm not dealing with issues of loss because they don't arise, and the parties have said we're going to make further submissions, and I will take the board to that. But he then says, well, Mr. Opp's evidence, and that's the important thing. He says, well, Mr. Opp's evidence says that there would be a greater loss. When you look at Mr. Opp's evidence, Mr. Opp's greater loss is predicated on holding those investments until the 31st of December of 2009, of which there's no evidence at all that the investments would be held that long. And indeed, the evidence, which I will take you to, is that Investcorp was already starting to deleverage the investment in October 2008. So, my lord, in my respectful submission, it is not a fair inference to say that he must have rejected the evidence which we say he failed to consider, and indeed the Court of Appeal.
This is the evidence of your client personally, is it?
Yes.
I see. I mean, so you're basically asking us to make a finding as to what your client would have done for the first time.
Well, my lord, it's not a matter that has hitherto been subject
Well,
to...
I understand that, but I mean, there are two difficulties. One, which I've just been discussing with you, is the difficulty arising from the findings below. But let's suppose that difficulty can be overcome. We then have the difficulty that we have to make a positive finding on the basis of a transcript of your client's evidence, evidence which which the judge didn't trust for the first time. I mean, that is a problem, isn't it?
It is a problem, but my lord, I am faced with the problem that the judge, that if the board is with me on liability, then we are faced with these problems, because the judge did not go on to make the necessary findings that the board can act on.
You say, I think, that the mistake the judge made was to ask himself only what the investment company would have done, and not even consider the possibility that Mr. Sadik would have
Absolutely. I mean, absolutely in terms, my lord. So it's a partial exercise, and that's why we attack it as a matter of law, because it's an incomplete.
But supposing you're
analysis.
right about that, what are you asking us to do?
Well,
Make the finding ourselves or remit?
well, it may ultimately. I would obviously like to see some finality after 6 years, but my lord, it may be that one rather reluctantly is forced to remission. But I hope to persuade you that there are a number of courses open to the board.
And there's a clear finding as to what investment would have been made if you're right about the construction of the SPA, and they couldn't do it through Blossom Wand, or they couldn't do it by direct leverage.
He made that finding.
He made that finding quite clearly and distinctly. But you say that simply leaves open whether your client would have blown the whistle at some earlier stage if there'd been full disclosure.
Yes, my lord, and it gets more complicated than that, because he's finding that there was no loss.
It's just based on running that investment through to conclusion.
Yes.
Yes, no, I understand.
Yes.
But anyway, you're going to take us to the evidence from your client, which you would be relying on.
My lord, it's in our case, and I will certainly...
Can you give me the paragraph number?
if you'll bear with me for one moment, I have all the references.
Well, if you give me the reference to your case, I can follow through the references
Yes.
that you give there. Is this
It is-
footnote
it is-
105?
I have it. It's in our case that it is footnote 105, which you will find on 2669 of the e-bundle, and there are references to the transcript there. I can just for the note, the references to the transcript are also in MS 26, pages 1853, 1855, 1880.
Are they the same references?
Yes, my lord.
You haven't got time to take us to those. We'll read them for ourselves.
I'm obliged, my lord. So just going back to where I was, if I may, so we do submit that this is a case of inducing Mr. Al-Sadik to refrain from exercising his rights. We submit that there is no material difference between inducing someone to enter into a contract and inducing someone not to terminate a contract. And here, of course, it is common ground that Mr. Al-Sadik did not discover what we say we submit was the fraud until the 2nd of March 2009 at the earliest, and it's never been suggested that he acted unreasonably thereafter. The fifth proposition of law that I should like to make is that where the loss is consequent upon a breach of duty that is fraudulent in nature, the principal remedy will be rescission. But while absent fraud, a breach of duty of disclosure will, as a general rule, give rise merely to a right of rescission. Where the breach of the duty of disclosure is fraudulent, the party to whom the duty is owed and the party to whom the duty is owed suffers loss by reason of the breach, he may recover damages for that loss under the tort of deceit. And the authority for that is Conlon and Sims in the Court of Appeal, which is in volume 2 of the authorities, electronic bundle MS 74, page 3171. I'm not sure that I need...
Is the whole of the submission you're making to us now dependent on there being a finding of fraud?
Not all of it, no.
Right.
I'm starting at the highest and working down.
Okay.
But I'm still on the subject of fraud on my next proposition, that where a party is entitled to recover the losses flowing from a transaction caused by deceit, it is not necessary to embark upon a hypothetical reconstruction of what would have happened had the deceit not occurred. And I need to take you back to Smith Newcourt for that, at volume 4 of the authorities, tab 102, page 4015 in the authorities bundle, where in the speech of Lord Steyne, he refers to Down and Chapel and the judgment of Lord Justice Hobhouse. And perhaps may I ask the board to read that to itself?
From where to where precisely?
From between letter C and D, beginning in Downs and Chapel,
Yes.
and ending with the words Downs and Chapel was wrongly decided.
Very
next to
well.
letter G.
Sorry, which page are we on?
We are on page 4015 in the electronic bundle.
That's all right.
Internal page 283 of the
Yeah,
judgment.
thank you.
Right, we'll read that now.
I'm obliged, my lord.
Yes, which is what you said.
Yes, my lord.
Very well.
We say that this flows from the principle it's no defence to show that a party would still have entered a transaction absent a misrepresentation as long as the misrepresentation formed a real and substantial part of the inducement. And we accept, of course, that it is open for a defendant to prove that it did not form a real and substantial part of the inducement. Then my final proposition...
But we're here talking about a pre-contractual inducement.
Well, my lord...
Whereas I thought all you have left in your grounds of appeal here is a post-contractual fraudulent non-disclosure.
Yes, which is what I...
But the contract's already happened by then.
It's the previous point that I made, that we say that the inducement was the inducement not to terminate.
Yes.
And so we say that this is authority for the proposition that you don't have to involve yourself in counterfactuals and hypotheticals.
Well, in relation to a pre-contractual inducement that is followed by a contract.
Yes, my lord.
Yes, but where you have an existing contract...
Yes.
And there is a deceitful failure to comply with a duty of disclosure in the course of the performance of the contract, how can you just turn that dictum inside out?
Because that induces you not to exercise the right to terminate the contract. Sorry.
Yes.
That induces you not to terminate.
Do you think it follows a matter of law that the court therefore automatically assumes that you would have terminated the contract?
No, my lord. No, of course not.
So I don't understand where all this is taking you.
Where it's going is, it is my case, at its highest, I accept, that I was fraudulently induced not to exercise my rights to terminate.
Yeah.
If I'm right about that, then what I say is it becomes immaterial to consider a hypothetical situation, because then the exercise to be undertaken by the court is to look at what loss flows as a matter of causation, and I come to causation in my next proposition of law, as a matter of causation from the inducement not to terminate.
But, I mean, an inducement could be deceitful in all sorts of different ways. Are you saying if the deceit consists of a deliberate intent to stop somebody exercising a right to terminate?
Yes.
Not merely that it's deceitful, but for that purpose?
My lord, I'm not sure whether I have to go that far in the submission. If it is a material, if it is materially affects the decision not to. Yeah. Again, we're back to Edgerton and Fitzmaurice essentially. If it's material to the decision not to terminate, that's enough.
Enough for what?
Enough for there to be liability.
Yes, but how do you...
But you say rescission comes into it there.
Well, it's not rescission, is it? It's termination. It's
Yes,
redemption partway through the contract. But what you're saying is if you establish that,
yes,
you're entitled to damages for not having had the opportunity to do so.
My lord, yes.
Yeah.
You do want damages, but I thought you, in particular, wanted rescission.
Yes, but my lord, this is an alternative way of putting it. And
Why?
my lord...
Well, it's fundamentally different because
it is fundamental.
If you're entitled to rescission, itself a large question. You unpick everything that's happened in the past, whereas a termination would not have that effect.
I agree. And my lord, this is the whole point of looking, as we say, at the case in a holistic view and the impact of non-disclosure, whether it is fraudulent, whether it is not fraudulent. My lord, I will come to it, but I had put on the bench, because I couldn't do it in any verbal way, a graphic.
But are you saying you value the right of rescission or the right of redemption from the moment the true information should have been given, rather than construct a hypothetical under which it's assumed that your client would have redeemed, or do you have to prove he would have redeemed?
My lord, what I say is that if I prove that there was an operative misrepresentation which caused me not to exercise my right to redeem, then I am entitled to the damage that flows from that failure to exercise. Or
Well, that involves you proving you would have redeemed at the earlier date.
My lord, yes.
Otherwise, your causation case doesn't stand up.
My lord, I accept.
Oh, I see. Okay. All right.
And that's the point of footnote 105.
Yes, exactly, my lord, yes.
Well, yes,
I've been looking at some of those, and I don't want to take time over it because you haven't got time to do it, but certainly the early ones are when Mr. Sadik is being cross-examined about his assertion that he was entitled to a guarantee.
Yes, my lord.
Does that help us much on whether he'd have redeemed for the failure to provide the notice, that the reports that you say he should have had?
My lord, the point I make, and the highest I can put it, is this, that there was evidence before the judge that he would have exercised his rights. That was not. It's a point essentially that I was answering with my Lord Sumption a moment ago.
Yeah.
And one comes back, I'm afraid, to the same position.
Well, we'll read them for ourselves.
Yes.
Yeah. All right.
Now, what about this diagram?
Well, my lord, may I come to it in a moment when but I was just foreshadowing that because I said, first of all, that one looks at fraud and non-fraud and the various options, and I recognise the difference between redemption and rescission. Because this is not a straightforward case. There is an interaction of a number of causes of action and external factors. Because not only did Investcorp breach, we say, the terms of the SPA by investing in a company that was not authorised, which had the effect of disguising the true nature of how Mr. Al-Sadik's money was invested. It also engaged upon unauthorised borrowing using that company, but then, in addition, it did not comply with its disclosure obligations, and the judge found that there was a breach of its disclosure obligations, and they deprived Mr. Al-Sadik of the knowledge enabling him until October 2009 to understand what had happened to his investment, by which time, of course, there had been enormous upheavals in the market over the preceding 12 months.
But it would have been rather difficult for your client to say at one and the same time, I believed that I was getting a guaranteed return of 45% over 3 years, and if I'd seen what was going on, I would have withdrawn my money entirely. Why should he mind if the return
my lord,
was guaranteed?
I'd anticipated that was a question that I might.
Well, I'm glad to be so predictable.
It is. I didn't mean it in that way, my lord. But
No. Predictability is a virtue.
no, but certainly in a judge, yes.
This is a big point, so answer it now. Please.
I will do. My lord, and essentially, I'm afraid my little friends can't have it both ways, because they are arguing against us that there were harsh findings of the judge against my client, and that he was saying he had a guarantee, and consequently, you can't accept that he's a witness of truth. On the other hand, they seem to be arguing, well, if he genuinely believed he had a guarantee, why would he bother with the question of redemption? There are a number of answers to that. The first one is perhaps a slightly forensic one, that my little friends can't have it both ways. However unpalatable to my client, and the findings were very unpalatable to my client, but as an intelligent man, he accepted advice. He did not seek to appeal those findings. It's also unpalatable to my learned friend's argument that, well, in that case, if he genuinely believed, would he redeem? We are stuck with the judge's findings, and the judge has found that my learned friend, that my client, not only was there no guarantee, but my client knew there was no guarantee. And I have to hold my hands up and say, well, in that case, that's the factual background.
Because your client told lies on that subject, we ought to believe him when he says what he would have done had his entire case been destroyed before rather than after
It's not an easy situation from my point of view, because my client doesn't accept clearly that.
Did he ever say, addressing simply the deficiencies in the reports, that had he known the true position, he would have redeemed?
Well, my lord, those are the footnote points.
And you say that it's to be found there, do you?
Yes, my lord, I do.
All right, well, I'll have another look.
Okay, because he said he would have raised a red flag.
That's the closest he gets to it.
My lord, that was the evidence.
Fair enough.
But can I answer the question also in a less forensic and I hope more factually based way? That even if he did believe that he had a guarantee, as the Court of Appeal noted, he went to the trouble of negotiating reporting obligations upon Investcorp, and he went to the trouble of negotiating the right to redeem. And he recognized that he might need liquidity at some point. He recognized that markets may change. And of course, the guarantee would have locked him in for 3 years. And they're clearly giving him the opportunity to redeem after 1 year meant that even if, against the background of genuinely believing that he had a guarantee, he was still contemplating the possibility that he might redeem in accordance with Clause H. So even if I don't have to play, as it were, that forensic two-step in terms of accepting what is an unpalatable finding to my client, nevertheless, the facts do indicate that he did reserve his position to redeem, even in the light of genuinely believing that he had a guarantee.
But Mr. Beck, if I've understood your chronology right, he knew the true facts almost exactly a year after this transaction was set up.
Yes, on the 2nd of March.
2nd of March, he knows the true facts, and the money wasn't invested until, was it the 3rd of March, the previous year? So he knew everything which you say he should have been told much earlier about whether he should redeem, as early as he had a right to a full redemption.
And he did.
But then,
Not till December.
He rescinded in December.
But he allowed 9 months to pass.
Yes.
Instead of the red flag going up the moment that the horror story was disclosed, he waited 9 months.
There was a great deal of correspondence between solicitors during that period, seeking to discover what had happened.
But I thought it was common ground that it was apparent what had happened from the 2nd of March 2009.
It was apparent that Blossom had been used, yes, my lord.
Yes, so, if the position was that he would have put up a red flag and redeemed, why didn't he do it then? Why does one need to correspond for 9 months with solicitors?
Well, my lord, this is not something that's in the record, because it's not a point that's been raised before as to the reasonableness of his conduct after.
Well, this isn't a mitigation point. This is the question is.
It's causation.
Yes.
You're saying that he wasn't able to exercise his right of redemption because the true facts were concealed from him.
Yes, my lord.
And but you're now, I think, accepting that he was aware of the material facts in early March of 2009.
Yes, my lord. And there was very, very considerable correspondence thereafter. And there were letters before action.
you might have a much more modest case that if he'd known the true facts earlier, he could have, I think he had a right to redeem up to was it 30% in the first year?
In the first year, yes.
He might have had a much more modest facility to redeem, I don't know on what notice, and where he would have ended up in terms of the loss curve if he'd have tried to exercise.
Well, yes, my lord, and that's what I wanted to come to about the various different options, depending upon the findings that follow from that. So because that was the point that I was just about to make, if I may, there are an interaction of a number of causes and different factors And I mean, as I say, even if you do not treat the breach of clause F4 as fraudulent, you can't ignore it in our respectful submission. It occurred and it formed part of the facts within which any counterfactual, for example, would be framed. So if I may deal first with interaction between unauthorized investment and borrowing, we accept you can't differentiate or isolate between losses consequent on unauthorized investment and unauthorized borrowing. And the judge held the most reasonable inference would have been that but for the unauthorized investment and unauthorized borrowing, Investcorp would have allocated 50% to LDSF times 3 and 50% to SMFCO. Now, my learned friends correctly say that that is not challenged as a finding of fact. We challenge it, as we do in our notice of appeal on ground 2C, as a matter of law, because the finding goes nowhere near supporting that had Mr. Al-Sadik proved his case, he would have suffered no loss. We say it goes nowhere near approaching the level of detail necessary for an appropriate counterfactual. It fails to address what happened in the market following 2008. It fails to address whether Investcorp would have maintained that asset allocation to 31st December 2009. The evidence was that they were seeking to deleverage the portfolio from October 2008. May I just give you the reference, given the time? You'll find that in the record at bundle 15 at page 6095. And perhaps most importantly, it fails to address what Mr. Al-Sadik would have done. It's clear he had at least 4 options, we say. He could have decided to let Investcorp carry on, in which case the court would have to decide what Investcorp would have done. He could have exercised his rights of redemption as to 1/3 and the remaining 2/3. He might have asked Investcorp to deleverage, or he might have rescinded the contract for fraudulent misrepresentation if the situation supported that. It all depends on what Investcorp did and when and how Mr. Al-Sadik learned about it. Because if, for example, Investcorp made authorized investments in LDSF and SMFCO, but Mr. Al-Sadik received reports, as he indeed did, that did not show he was leveraged at all, he might still justifiably feel deceived and try to rescind. The judge did not consider the effect of the breaches of clause 4, F4. And so can I turn to that? Because we say any counterfactual must be framed within the context of the finding that Investcorp failed to report to Mr. Al-Sadik, and he was positively misled about his investments so that he was unable to understand and monitor them. We submit that the correct hypothetical would be to ask what would have happened if Investcorp had not breached clause A, but had breached clause 4 in the way they did. We say he would still have been deprived of the information necessary for him to consider his options and exercise them in an informed manner.
As to that, the Court of Appeal said you hadn't pleaded a case on that hypothesis.
My Lord, can I look at it?
Yes. I'd certainly like to know your answer to it.
Yes, I will certainly give you my answer to it, if I may do that in reply.
Okay, well, maybe.
But we submit that Mr. Al-Sadik would still have been deprived of the information necessary for him to consider his options and exercise it in an informed manner. And I've referred to the evidence in footnote 105. I'll not go over that again. I've also addressed the issue of Mr. Al-Sadik's guarantee. And it is significant that the Court of Appeal observed in argument that he went to the trouble of negotiating a mandate with investment classes, reporting provisions and redemption rights. And he did not treat the investment like a bond paying a 45% coupon after 3 years. And indeed, the evidence was he wanted to retain liquidity. And so we say it is a selective misreading of his evidence to focus on the words about personally indifferent about receiving reports, because as my Lord Sumption noted before, Mr. Zaidi, his investment manager, was doing the monitoring. So that brings me to this graphic that I just would like to take you to very briefly. And we did find it rather difficult to put the alternatives in verbal form, so we felt it was easier to put it in graphic. But just the way it works, we hope it's fairly obvious, is you've got the alternative of breach and no breach in relation to authorised borrowing and unauthorised borrowing and Clause A. You've got breach of Clause 4, which is taken as a given since the judge found that as a matter of fact. Then you have the alternatives of whether it's fraudulent or not fraudulent. And then in that case, you have the destinations for the combinations there. So at its highest, and I'll just take you to the highest and the lowest, if I may. So at its highest, you have 1 + 2 and 5 + 6. So breach of Clause A, breach of authorised borrowing, breach of Clause 4, and fraudulent breach. And then we say that the options there would be open, that he could validly rescind. He would be entitled to fraud damages if, for example, it were felt that he was overcompensated by rescission because he always was going to bear some market risk. Damages for unauthorised investment, damages for unauthorised borrowing. I'll come to damages in the last 10 minutes, if I may. Does he accept a repudiatory breach? Loss of opportunity to stop leveraging, loss of opportunity to stop and roll back leveraging, and loss of opportunity to exercise rights of redemption. That's at the highest menu of possibilities. At the very lowest, we see 3 + 4 and 5 + 7. So that's no breach of Clause A, no breach of Clause 4, but a breach of Clause F4, but a non-fraudulent breach. And the highest I can put that would be that he lost the opportunity to stop the leverage or roll back the leverage, and the loss of opportunity to exercise his rights of redemption.
You're not saying by the use of the words lost the opportunity that he can get the benefit of a loss of a chance, as I understand it. You're saying he's got to prove that he would have exercised the opportunity.
Yes, I think I've accepted that as a proposition.
Yes, thank you.
When do you say that he would have redeemed?
I'm sorry to answer a question with a question, if you'll forgive me. In what circumstances?
Let us suppose that from the outset he had received full and correct information. When do you say that he would have redeemed?
It full and correct information. If he had been told from day one that Blossom was being used.
For leverage purposes, yes.
For leveraging purposes.
Yeah.
My Lord, I would submit that on the evidence as it is, he would have redeemed immediately, because that was not what he had bargained for.
I mean, one view of the evidence references that you've given us is that, first of all, he says that he would have responded by writing a letter saying they're doing the wrong thing, or perhaps, he said, got so scared that he would have redeemed. But that evidence is given on the footing that this had arisen at a time when the problems had become apparent and when it seemed that Investcorp were still leveraging their investment strategy at a time when other investment managers had stopped doing so.
Yes.
So when do you say that would have been?
Well, my Lord, there is one piece of information
presumably.
which is quite helpful on that, that I didn't take you to in detail before, but I did say that in the chronology it might become relevant on the issue of damages. And we're actually in May of 2008, and I wonder if I could take you to that. Could I take you in the record to page 8389? 21.
That's a memorandum.
That is an internal document to Investcorp.
Mm-hmm. This is the hedge fund review.
Yes. Under hedge fund review, if you would just have a look at points 2 and point 3, the reason I flagged it up before and said it may become relevant on the question of damage is because it is some indication which supports the evidence to which you've just, with respect, adverted about what other hedge fund managers are doing, and indeed what they themselves were doing in May. There was some reservation about the use of leverage as early as May of 2008, which gives some colour to, we would say, which gives some colour to that evidence to which my Lord has adverted. Yes, my Lord, I would like to move on in my last 10 minutes or so to damages, just so I can cover everything. Clearly, if the appellant were entitled to rescind the contract, the position is straightforward. He's entitled to his 136 million back, less the redemption proceeds plus interest. If
You
the
mean
view is
rescind ab
taken...
initio?
Sorry?
You mean rescind ab initio?
Yes, my Lord, yes.
Which of your cases on this appeal supports that outcome?
That would be if he were the victim of fraudulent misrepresentation, then he's entitled.
What, a pre-contract reference?
Well, my Lord, I argue that a post-contract, my learned friend makes some noises off.
Apologise.
Right.
I did make a noise off, and I apologise.
I'm listening to you.
But I was so amazed by the public. That is why I made the noise off.
Well, my learned friend is not too old to learn. So what I suggest is that there, as I said in my submission, there is no qualitative difference in our respective submission between being induced to enter into a contract and being induced not to.
Oh, I see. So it's your point, it's your turning the locked-in claimant inside.
Yes, ma'am.
Yes, all right.
But I mean, there's a difference, isn't there?
You've been through all this.
Yes.
You must move on. But what's your best authority on bringing in fraud-inducing a failure to terminate as being equivalent to a pre-contractual misrepresentation, fraudulent misrepresentation?
Well, my Lord, it's a bold submission which I accept, but I rely on those parts of Smith and Newcourt talking about the retention.
I see.
Of
But that was entirely in the context of a pre-contractual misrepresentation.
well, my Lord, it
where
was.
It was the only effect of the retention was that the damages increased.
Yes, my Lord, my Lord, I accept that, but intellectually one asks oneself is there a qualitative difference between the situation that I...
Well, if the fraud occurs after the contract is made, what is it that you are induced to do that you are rescinding? You can't rescind a retention. You can only rescind a contract.
My Lord, that is so, and that perhaps brings me to the better argument that I might be entitled to damages in those circumstances, and that would be my second.
Of course,
fallback.
yes.
And it clearly would be, in those circumstances, in our submission, appropriate to strip out all losses consequent on the leverage that were concealed from Mr. Sadik. But as I said, he always accepted there was a market risk, and the experts had tried to capture that, and indeed there was an agreed experts report on that. The plaintiff's expert, Mr. Matthews, produced two scenarios, what he called scenario 3A and 3B. And scenario 3A is where the identical investment decisions would have been made in the absence of leveraging. And 3B is the scenario where the original assets purchased with cash, as it were maintained throughout the life of the portfolio. For the reference, for the record, can I just give you the reference to that and then take you to the agreed experts report? Mr. Matthews explained what his scenarios were at core tab 21, which is in bundle 3 at page 1530, paragraph 7.6. and at paragraph 7.11 at page 1531. So the experts agreed the figures as figures, and you will see that in the core, and I do need to take you briefly to the core on this and the agreed experts report. You will find it in tab 23, bundle 4, page 1731. And so the experts agreed agreed the figures, and we just see on page 1731 that in fact Mr. Opp, who was the defendant's experts' figures are slightly higher than those of the plaintiff's expert, Mr. Matthews. The position is more complex if one approaches the assessment of damages on the basis of the interaction of what we say were the three breaches of the SPA and on the hypothesis of how Mr. Al-Sadik might have reacted when he learnt the truth at various points. The closest the experts came to such an analysis in advance of seeing the judgment was Mr. Opp's Quantum 4, where he hypothesized, albeit for a different purpose, on Investcorp ceasing to leverage on the 30th of June. And the experts agreed that Mr. Al-Sadik would therefore have avoided losses of either 44.3 million dirhams or 48.2 million dirhams, depending on how quickly one removed the leverage. And one finds that in the document we're looking at 1727.
So the factual hypothesis here is that your client says what to Investcorp when?
He says in June, stop leveraging.
In other words, cancel the 1st May leverage.
No, this analysis accepts that the 1st May leverage stays in place.
I see. No more.
No more.
Now assuming that he did not redeem, but simply
Yes.
altered his investment instructions.
Yes.
Was there any evidence given in support of that hypothesis? That's not what's covered in footnote 105.
No, my lord. This is all I'm saying. What I'm saying, my lord, is that this is the closest the experts came to this. It was not for the purpose of this hypothesis that the experts came to this. But this is the nearest calculation, no. and I accept this by way of an example.
I see.
Of how it was done, because the problem is that the experts and counsel, my lord, I know I have about 2 minutes left, I think.
More than that.
I'm obliged.
You've got about 12 minutes left.
Oh, thank you.
Yes.
The point is that the breach of F4 meant that he was unaware of leverage at all. But so if we are then trying to hypothesize that somehow the breach of F4 didn't occur and he became aware of leverage, then one's looking at the possibility of how he behaved. This hypothesis was that he did become aware of leverage in June, but the leverage was always hidden from him, which is the problem with the interaction with clause F4. And that's a finding of the judge that is not in any way disputed. And we've been through the facts which show that that he was only ever told he was actually in unleveraged investments. But they did hypothesize, the experts, what would happen if he did tell them to stop leveraging in June. And at paragraph 1.27, on page 1727, we see there are two scenarios that the experts agreed. The first one is...
what paragraph?
This is 1.27 on page 1727.
Well, Sorry, I must have the wrong 1727, but no man.
Yes?
So those are the losses on two assumptions about how quickly it would have been possible to unroll the leverage. Mr. Matthews, the expert for Mr. Sadik, also approached the same assumption, but on the basis that the existing leverage was wound back. I just give you the reference to that, which is in bundle 8 of the record at page 2828. But we do see that in the paragraph before us, after the one we've been looking at, 1.28 on page 1727, the experts agreed that Mr. Matthews' scenarios A and B, as opposed to Mr. Matthews' adjusted quantum 4, more accurately represents the exclusion of all leverage across all of the underlying investments. We recognize that these are, in a sense, examples of how loss may be approached when one has the very complex interaction of the breach of F4 with the other breaches, if they be breaches. And the question of whether or not Mr. Sadik was entitled to rescind or was entitled to damages attributable to either a fraudulent misrepresentation or attributable to unauthorized investment and borrowing. And ultimately, it comes to this. It's not the most satisfactory position, as I accept, but the board may ultimately feel, and my Lord Sumption ventilated the possibility before, that it may be in the appropriate interests of fairness to both parties, that they be permitted to make the further and detailed submissions, that indeed when you look at the judgment, indeed the last paragraph of the judgment, that both the parties and the court expected would be made when the decisions on the liability of the judge were given. And indeed there is something of a discontinuity, in a sense, between his paragraph 411 of his judgment, where he says there was no loss, and paragraph 7.6, where he says, well, I haven't really considered the questions on loss, and the parties have agreed that more detailed submissions should be made when they know the shape of the judgment. And so, obviously, in an ideal world for my client, I would like to persuade the board that he was the victim of fraudulent misrepresentation and at least gets damages for that. But I recognize, I hope with a degree of realism, that if the board feels unable to make that findings, it may nevertheless feel that this might be a case where further consideration should be necessary on the issue of quantum.
You mean by way of remission?
Yes, my lord. Unless I can assist the board further in the very few minutes that I have left of my time, those are my submissions.
Any questions?
Apparently not. Mr. Black, thank you very much indeed.
Thank you, my lord.
Mr. Starr. Lord Faulkner.
My Lord, I submit that there are 6 issues for the board to decide. First, was the transfer of funds by Charlotte to Blossom an unauthorised investment within the meaning of the SPA? Secondly, was the application of leverage by Investcorp through the Blossom structure as opposed to applying leverage through a branded Investcorp feeder fund unauthorised under the SPA? Thirdly, if Investcorp acted in breach of the SPA by transferring the funds to Blossom, what loss and damage, if any, did the appellant suffer by that? Fourthly, if Investcorp acted in breach of the SPA by using the Blossom structure, that's the first layer leverage issue, what loss and damage, if any, did the appellants suffer by that act? And then there are what I've described as the 2 deceitful non-disclosure issues. Firstly, has the appellant got any viable claim for rescission or anything else left, even if he were to establish that the judge and the Court of Appeal were wrong to conclude that the failure to comply with F4 was not deceitful? And then finally, should the board overturn the finding that the breach of F4 was not deceitful?
I mean, we can help you on 5 and 6.
My lord, yes.
The submissions on deceit and fraud were made prior to the short adjournment, and we took the opportunity of discussing carefully the submissions that had been made. And the upshot is that we don't need you, Lord Falconer, to address us on whether the various shortcomings in terms of disclosure and reporting were deceitful. But don't forget that Mr. Black has just said even innocent breaches entitle him to damages. So I'm not sure we can entirely cross out 5 and 6, or perhaps there's a 7.
I take it that you do not wish me to address you on the issue, was the judge and the Court of Appeal wrong to conclude that the breach of F4 was not deceitful?
We don't need...
So that gets rid of my 6th issue.
It does.
My lord. My lord, in those circumstances, I'll obviously bear that in mind. Can I make the following points on the facts, then go to each of those issues? The following facts should, in my respectful submission, not be treated as in dispute before the board. First, the investment which both parties contemplated was one which would involve leveraging the appellant's equity investment of 500 million dirhams. That is not significantly in dispute, but the clearest reference to it you get from the core record documents, volume 2, flag 12, page 753 in paragraph 6, where in his closing speech before the trial judge, my learned friend accepted that that was the position. Secondly, without leverage, the contemplated levels of return, namely 45% over 3 years, could not be achieved. And that's FARA 5.20 of the judgment, which is in the core bundle at page 98. Thirdly, the levels of leverage required were explicitly described in pre-contractual discussions. Could I just ask your lordships quickly to look at the investment proposal, CRD, that's core record documents, bundle 6, flag 41.
Page.
It looks like that.
Page?
2459.
In the record?
In the core record. I mean, I don't know what you call there's a core bundle here for the court, and there's a record.
So it's in the
This is the proposal of the 28th of January.
Correct, my lord. It's the investment proposal which the judge refers to. Just if you go quickly through it, 2468, 2460, you see what the targeted return was. 2461, look at the third bullet point under the second bullet point. Leverage at each underlying portfolio is taking into account portfolio viability. Then if you go to 2462, you see the pie chart. Diversified Strategies Fund times 3 equity leverage. Event-driven fund times 1 equity leverage. Single Managers Fund times 1 equity. And then they refer to funds and leveraged. That might well be a reference to LDSF. But the point I make, and the judge was influenced by, not because I made it, but because it existed, was it's clear that this document is explicitly spelling out leverage was the key, and these are the levels of leverage that would be required. Go to 2463, and in the pie chart, again, there is the specific references to the amount of leverage. 2464, these are, quote, indicative terms, how Investcorp might deliver it. And you'll see investment amount, leverage diversified strategies fund times 3 equity leverage. SMFCO, that is also a leveraged fund, initially ×1 equity leverage, leveraged event-driven fund, that's another feeder fund. The key point, though, that I make is that the strategy was leverage, the method being identified as a possible way of doing this in the indicative terms is through feeder funds, leveraged feeder funds. My Lord, that's the investment proposal. My Lord, the contractual structure put in place to affect the investment in hedge funds was, and we've seen this, I'll go through it quite quickly, the appellant subscribes 500 million dirhams for 500,000 non-voting preference shares in Shalott. Those shares are held by Investcorp nominees on behalf of Al-Sadik, Mr. Al-Sadik, the appellant, on the terms set out in the SPA. There were 100 voting shares held by Investcorp nominees number 2. That is in effect on behalf of Investcorp. I don't ask you to get up, but it's at para 6.1 of the judge's judgment, which is in the core bundle at page 100. The directors of Shalott are all employees of Investcorp. The way it works, I submit, is Shalott are to manage the investment account for the purposes set out in A, which is the investment in the hedge funds. They, under D2, that's the directors, have the power to do anything they regard as, quote, necessary or desirable to affect the purposes of this investment or otherwise manage the affairs of Shalott. That's D2. The consequence, I respectfully submit to the board, of these arrangements is the whole of the economic interest in Shalott is held by the appellant, because he owns effectively all of the non-voting preference shares, but the management of it is exclusively in the hands of Investcorp. My Lord, as I've indicated, at the time of the investment proposal, it was envisaged that the leverage would be added through feeder funds, but subsequent to the investment proposal, as the judge specifically found, Mr. Al-Sadik wanted easier access to his funds if things weren't going well, which meant that the feeder funds weren't appropriate. So they had to replace the application of the leverage in a different way. They decide, in the light of this change, to do it by putting 50% of his equity in DSF, 3 times leveraged, and 50% in single managers, individual single managers fund, also 3 times leveraged. There's no individual feeder fund that can achieve that, so they set up the Blossom structure, which allows them to give the same economic equivalent. The participants within Investcorp who took the decision to set up that structure, the judge specifically found, took it for granted, without applying their minds to the SPA, that this was something that they were entitled to do.
Did it involve greater leverage than the investment proposal feeder fund idea?
No, not in practice, and indeed, as a result of the leverage being added gradually, rather than all at once at the beginning, the amount of leverage that had been applied by the time, as it were, the balloon goes up, was less than it otherwise would have been. So, for example, it was envisaged that the LDSF investment would have involved 3 times leverage on DSF right from the beginning in March. Overall, the portfolio, as the judge found, was only 1.4 times leveraged by the time the dispute arises. It is for that reason, it's because the leverage is less when the market is plummeting, that his losses are less than they would have been if the original scheme had been put into operation. One of the advantages...
But the original scheme was never agreed, was it? It was
No,
a proposal, and it moved on because Mr. Al-Sadiq needed access to his funds.
Precisely. That's exactly right. But the reason, the judge finds as a fact that had Blossom not been used, what Investcorp would have done is do SMFCO, which is 1 times leverage, and LDS, which is 3 times leverage, and they would have done that right from the outset. If you go into a non-tailor-made fund, then the whole leverage is applied straight away. One of the advantages of having a tailor-made fund is you can apply the leverage gradually over time, which is what happened here.
So to understand that the rights of redemption would have been more restrictive if the monies had been invested directly in LDSF and so forth?
No, there was going to be a fund called the Credit Opportunities Fund, and that required you to lock in. The Credit Opportunities Fund was in fact not, I think, a leveraged fund, but it's a fund with high risk, because what you were doing was investing in company bonds of a particular sort. And that required you to lock up the money for the whole of the money for 2 years. And so that was why. It was not the leverage issue at all in relation to that.
You have a paragraph in the judgment where he finds that the overall leverage was 1.4.
Yes, hold on. 621, my lord. If I
Page?
It's 1.7, I'm told.
Sorry, 1.7. It's judgment 621.
621, yes, and it's page 117 in the core bundle.
Thank you. And was that the highest point or the highest overall by the time they deleveraged a bit during the bad time?
That was the highest overall. It may have got higher as the thing dropped, the leverage would go up, because if your value is being eroded.
Well, but they hit their loan to value limits with White Ibis, and
but then the new limits were agreed after that. Because the way it was done was it was all being negotiated with RBS, and where they were trying to negotiate terms that reflected what they wanted to do. If those terms got into trouble, then they could renegotiate the terms. My lord, just going on with the facts as found by the judge, the reason why Blossom was used was in order, as the judge found, to present, quote, a clean structure to the bank, in the sense that the bank, RBS, would have security over all of Blossom's assets. And it's audited, that's Blossom's audited statements, would tell the bank what it needed to know about its asset position. Unlike Charlotte, which could not be presented as a clean SPV in that sense, because it had other things that wouldn't be charged to RBS, in particular the currency hedges between dirhams and dollars, because Mr. Al-Sadiq was very keen that the currency of his investment was dirhams. The judge found...
Is that the retained million?
That's exactly, that's right, the 1.69 million retained, exactly right. It was also the fact that Charlotte presented its accounts in dirhams, whereas the borrowing from RBS was in dollars, so it needed a dollar SPV rather than a dirham one. Blossom was not set up by Investcorp to disguise leverage or anything else from the appellant. The FSP2 reports after the first one, provided to Mr. Al-Sadiq, expressly referred to Blossom. There was plainly no attempt to conceal the existence of Blossom from Mr. Al-Sadiq. None of the Investcorp employees believe that doing it this way, i.e. using what has been coined first layer leverage, was in breach of any agreement that they had entered into. They didn't consider there to be any distinction between first and second layer leverage. These terms aren't recognised in the hedge fund industry, and they all thought they had authority to do that. And the judge made that finding 4 times in his judgment, in paragraphs 510 at page 89, 517 at page 96, 520 at page 98, and 522 at pages 99 to 100. Further, Investcorp were under both the judge at first instance and the Court of Appeal held, they were under no obligation to the appellant before or after he transferred the money to Investcorp on the 27th of February, or before or after the SPA was entered into on the 1st of March 2008 to explain that they were going to use what is described as first layer leverage, or to proffer an explanation of Blossom. The judge and the Court of Appeal find that the only obligation on them was to comply with F4. So there is no breach of any sort, either alleged in this board or found by any of the other judges, that there was any obligation to say anything beyond the F4 obligation.
Of course, Mr. Kironde did say something, I think in June, about, well, why is there a Blossom?
Well,
and you'll have to deal with that answer.
Well, what the evidence in relation to that is that he mentioned something about the dirhams dollar thing. He gave evidence to the effect that he had no independent recollection of that conversation. The judge found that there was such a conversation, that it was incomplete. He takes that into account in all of his findings. He does not make a finding that Mr. Kironde in any sense deliberately lied to Mr. Al-Sadik. And you couldn't hang a finding of deceit on the basis of that. The judge was fully aware of it and reached a conclusion in relation to it. Remember, Mr. Zaidi is somebody that the judge has also separately found has sworn a false affidavit in the course of this case, and has also found that he is totally the creature of Mr. Al-Sadik and will do anything that Mr. Al-Sadik wants, and finds him a wholly unsatisfactory witness. Lord, just the reference for that is, I think it's, can I tell you in a moment or tomorrow?
Yes, do, please.
My Lord, going on with the facts, I've indicated there's no obligation beyond F4. Next, in the decisions which Investcorp had made about both asset allocation and the application of leverage, the judge found that Investcorp acted bona fide for a proper purpose in accordance with the SPA, and that's para 7.5 of the judgment. The judge found as well that Mr. Al-Sadik was told in October 2008 that the reasons for the high losses in the Investcorp investment, as opposed to another investment that he had in hedge funds and HSBC, was because of the leverage on the Investcorp investment. Now, Mr. Black, for entirely understandable reasons of time, didn't mention that fact to you, but it's from October 2008, at least, that Mr. Al-Sadik was well aware that leverage was the issue. And indeed, he must have been aware right from the start, because he had agreed in January 2008 to an investment arrangement that was based upon heavy leveraging.
So were there any losses prior to October?
There certainly were, yes, because in September 2008, Lehman's had gone bust on the 15th. The way it had gone was it had started off going down a bit. It had recovered a tiny bit. There was a tiny profit in June. July, August, September weren't great. And September, October was pretty bad. The reason he has the discussion in October 2008 is because he's getting incredibly cross that he's not making any money. And blow me down, in October, that's when he first starts to mention the possibility of a guarantee as being the basis of why he doesn't have to sustain the losses.
Do you have a reference for this October conversation?
3.21 and 5.14 in the judge's judgment. My London Junior, Mr. Levy, if one goes to 1.3, this is the Zaidi reference, he says this.
Yes, yeah.
This is Mr. Al-Sadik. His general demeanour in the witness box was that of an advocate, convinced of the merits of his case, but oblivious to the possibility that other witnesses might have recorded conversations, events accurately in their emails. I do not regard Al-Sadik as a reliable witness, and I generally prefer the evidence of Investcorp's witnesses where it conflicts with his evidence. Mr. Zaidi loyally supported his employer in a way which lacked all credibility, and I've come to the conclusion that he is not a truthful witness. That's 1.3. I just should also mention 3.19, which struck me as Mr. Black was manfully making the new case about when the thing would have, when he might have redeemed. He's talking about Mr. Al-Sadiq's evidence. Mr. Al-Sadiq's reaction to this email is consistent with his reaction to other contemporaneous written evidence, which appears to be inconsistent with his case. He disputes its accuracy or reasserts that it's flat out wrong. This is the reaction of someone who is reinventing and reinterpreting the factual story to suit his case. I say that simply because his case at the trial had a guarantee. I wasn't interested in any redemption. When that gets blown up, he then says, oh, I was very interested in redemption, which is what's happening now. My Lord, going on with the facts, Investcorp did breach their obligation under F4 to provide a monthly statement of the underlying investments. The way that they broke that obligation was that they should have said what the full amount, including leverage, was, which was invested in each of the funds, and also indicated what the amounts owing to RBS was. That would have been compliance. The judge found that, in fact, they netted off the figures, which Mr. Black has taken you through, by simply giving the net figure in each without identifying the amount of the leverage or what the full amount of the investment was in each of the funds. The judge also found
So are you saying that as a net figure, those figures were correct?
Yes, nobody disputes that.
They were true net asset values.
Correct.
Not of Blossom's investment in the underlying funds, but in, if you like, the client's investment into Blossom. I can never remember the intermediate company's called, but anyway.
Charlotte's the first.
Which requires you to knock off what's owed to RBS.
Exactly,
Yeah.
exactly. That's exactly right. And by netting them off, it made it possible for him, Mr. Al-Sadiq, to understand how the net asset value of Charlotte, which he was getting on the FSP2s monthly, could be calculated. So it was helpful to him because, as the judge found, what he was most interested in was how his investment was going. He wasn't interested in the detail, as he kept saying. If the Blossom structure had not been used, the judge found as a fact that Investcorp would have invested 50% in LDSF times 3 and 50% in SMFCO, which was a 1 times leverage, and that they would have done it in March 2008, right from the outset, and the consequence of that would have been that the losses would have been higher because the leverage would have been higher than in fact it was. And that finding is at 4.11, page 78 in the core bundle, which I just refer your lordship
Because
to.
of the timing point.
Sorry?
Because of the timing point.
Because of the timing point, exactly.
But is that a finding which took into account the fact that Mr. Al-Sadiq had stipulated liquidity requirements, which had originally
Yes,
not? It did.
It took everything into account in that respect. My lords, finally, I don't think anybody doubts that the losses here occurred because of the market crash. If you go to 1.13 of the judge's judgment, at page 34, he reflects that point. The only fact which the appellant challenges, apart from the construction points, is that the failure to provide reports under F4 was not done deliberately by Mr. Caronde. And as your lordships know, the only person whose credibility he is attacking in relation to this is Mr. Caronde's, nobody else's. And that comes from the correspondence around the SOFI, the Statement of Facts and Issues, and that is to be found in the appeal bundle document at page 2767. I don't turn it up, but it's a letter in which they say, the only fact we challenge is the honesty of Mr. Coronde. And my lord, if one looks at what is actually in issue in this appeal, could I just take you to the appeal bundle? Flag 56, page 2550. Four and 5 is the deceitful non-disclosure case. The issues in this appeal, the bank's breach of clause F4 was innocent or dishonest by reference to conduct. The thing, he was wrong to find it was innocent. And then the court should confirm the rescission of the SPA on the ground the dishonest breach of F4 was a deceitful non-disclosure. If you then go to 2584 in the same document, this is the grounds of appeal to your lord, to the board.
Sorry, 2584,
my lord. The Court of Appeal, this is 3 and 4, the Court of Appeal erred in fact in upholding the judge's finding that the bank's breach of clause F4 was innocent and not dishonest. The Court of Appeal erred in law in omitting to confirm the rescission ab initio of the SPA for the fraudulent breach by the bank of clause F4 or award damages. I take that as meaning they're saying you should have brought the whole thing to an end, you should have rescinded or given damages in lieu of rescission because of a fraudulent breach of F4. And then if you go to the appellant's case, para 93 and 94,
What page?
2682, flag 61. And then if you look at para 93, the Court of Appeal was therefore wrong in failing to confirm the rescission ab initio of the SPA on the 24th of November 2009 for fraudulent breach of clause F4. It is important to note that at that time the letter was written, it was not yet known to the appellant that the IMA was a deceitful document. I don't think that changes anything. So they're asking for rescission right from the outset. If you go to the letter of the 24th of November 2009, which is to be found in the Core Record Documents, Volume 6, Flag 53, page 2528.
Yes. In the record or the core?
It's
the core.
It's the core, volume 6,
Yeah.
flag 53, page 25.
Yes.
The letter starts at 2528, and you go to the page, it's 2529. If you go to the heading 3, the third claim, deceitful non-disclosure.
Yes.
If you just read that, it's a lot more than F4. It's a whole case about knowing from the outset and using Blossom as an engine of deceit, which in effect has been rejected by the judge. So,
yes, I mean, what's the point you're making here, Lord Falconer? The case has gone through various iterations.
No, I'm making a much more profound... This Mr. Black comes before you and starts to invent yet another case, which is in effect, I can have damages based upon when I would have been told about it, when it's absolutely clear that he did at one stage have a case saying Blossom was all part of an elaborate fraud. That got blown out of the water at every level. He appears from the documents before this hearing starts to be saying, I'm sort of still running that, and then spins a yarn to your lordships about, actually I'm claiming damages based upon the proposition that I would have, or my client would have rescinded when told in, say, June 2008 that leverage had been applied. So I am holding him to the basis upon which he said he was coming to the Judicial Committee of the Privy Council. And it's a very different case than the one that he advanced to your lordships. And that has a point beyond simply a procedural point, because as my Lord Sumption said, his case before the judge was, I have a guarantee, I'm not interested in the detail, and indeed I wouldn't have redeemed, he said. I've also got a case that Investcorp, even before this SPA was executed, were trying to deceive me, because his pleaded case was Investcorp had a terrible liquidity problem. In order to try to fill the hole in their liquidity, they tricked him into believing the investment would be on one basis, then used his equity to borrow huge amounts of money in order to fill their liquidity hole, Investcorp's liquidity hole. He accepted that case was bound to fail on day 26 of the trial, because there was absolutely no evidence to support it whatsoever. But my point is the case that he was advancing was big fraud by Investcorp, and separately I had the benefit of the guarantee, so I didn't mind either way. And now, well after the judge is given an opportunity to make any findings of fact on those issues, he invites the board to make findings of fact in relation to it. Now, the reason there is this difficulty is not because the judge failed to make findings of fact that he was asked to. It's because he was never asked to make any of these findings of fact about what would have happened had Mr. Al-Sadiq been told about it, because Mr. Al-Sadiq was never running a case like that, and he couldn't run a case like that because of his guarantee point.
From what the Court of Appeal tell us, there was simply no case based on innocent misrepresentation.
Yes,
correct.
And
a simple breach of contract.
yeah,
exactly.
And that, one might say that what you've shown us in the Notice of Appeal is consistent with the absence of such a case.
Exactly.
And the absence of any challenge to the Court of Appeal's proceeding on that basis.
Yeah, and perhaps the easiest way for me to show is to show you how the case was pleaded. If one goes to the re-amended statement of claim, which is to be found in Core Record volume number 1, at flag 7, at page 372 to 373,
I'm sorry, the page?
372 to 373. This is, it's a quite complex re-amended statement of claim, but this is how it ended up. Part C is a summary of all the claims. The third claim is deceitful non-disclosure. And I just invite your lordships to read from paragraph 16 through to paragraph 20.9 on page 374.
Do you want us to do that now then? No.
Oh, well, I can summarise it. It's basically saying that they were under a duty to disclose to him their intention to use Blossom, etc., etc. That duty arose in a number of ways. One of the ways it arose was because of clause F4, C 19.1. 41.1H on page 375 is a reference, in effect, to clause F4. And how they broke it, look at 20.2. And you see they refer to Part A, and he refers to paragraph 21 in Part A in 20.2. Does your lordship see that?
Yes.
And then if it goes to page 299,
Yes.
you can see the sort of deceitful non-disclosure that they were referring to there.
Yes.
And then if you go to the damage that they claim, it's at para 29 of the same document in part C, which is at page 380.
Yes.
And the point I make from that is they're basically claiming the whole sum back, which is rescission ab initio, plus damages for loss of opportunity, namely they would have invested the money in something else. So there's never a case that is advanced before the judge. The judge is not invited to make any findings that the loss would have been at a particular time. It was very telling that my Lord Sumption asked Mr. Black, when do you say you would have begun to redeem, or whatever particular remedy you would have sought? And he didn't really give an altogether satisfactory answer. Indeed, my recollection is that he asked my Lord Sumption some question in response to that. But surely the most basic thing that the Investcorp would be entitled to would be to know what the case was as properly pleaded. And the reason this is happening is because he's lost on his guarantee claim, and he's now trying to create a new claim. And it's much too late to do it. And this is not a forensic point. You can't come and give an account that is disbelieved about your guarantee, and then, once that's happened at first instance, execute a U-turn and say, okay, I've got another case now, which is that actually, had I been told, I would have redeemed at an earlier point. You've got to give evidence. It's not. I mean, the judge.
You're right. Of course, he's shifting his ground. But then, what the case that he's made, I think, against you is that the judge has found that you were in breach.
Yes.
and it is said he must therefore go on to address the question of what, if any, loss there was.
Yeah. And I think that
which involves asking the question, which involves asking, says Mr. Black, not simply what you would have done with the money if you had put in a proper report, but what he would have done if he'd known about it.
Yeah, correct. And I agree with that. That what the court has got to do is make a finding as to what the scenario would be.
Yeah.
And in my submission, it is he can't ask you to make it now if he hasn't asked the judge to make it. That's
I understand.
It's
a scenario in which, under I think Mr. Black's own concession, requires him to discharge the burden of proof that he would in fact have done something that would have caused him less loss than he's actually incurred.
Correct. And it seems...
you say, well, he didn't either plead or prove anything of the kind at the trial.
Exactly. And indeed, he was so busy pursuing his guarantee claim that he could hardly come and complain to this court and say, well, they didn't make a finding. But it goes further than that, because what was he saying to he was anxiously and earnestly trying to persuade the court that he wouldn't have redeemed below. If you go to 1401, which in the record, which is volume 3 of the core documents.
You say 1401?
1401, yes, my lord. Uh, 47 and 40, this is his second witness statement.
Yes?
Para 48 is the key one, when he's seeking to refute the allegation that he would have redeemed.
So is this the record or the core?
That's a core, sorry.
Core record.
Oh, it's the core. Well,
core record documents. It's very confusing, I agree.
To us poor screen gazers, we have a core and we have a record.
Well, for us, hard copy,
1471.
Core record documents, page 1401, para 47 and 48. That's Mr. Al-Sadik's second witness statement.
Yeah.
So Mr. Al-Khatib was saying that there was a threat to redeem. Is that right?
Mr. Al-Khatib was saying how he was threatening to redeem when he saw that the thing wasn't doing well, and Mr. Al-Sadiq responded, I wasn't going to redeem.
I see.
Well, you see.
But he was having his cake and eat it at that time, Mr. Al-Sadiq, because he was relying on the guarantee at that particular point. My Lord,
If he,
Well, you
if he
both
would,
turned round 180 degrees.
well, I haven't turned round 180 degrees. I wasn't concerned at that because he didn't have a case about the fact that
Contrary to the assertions of Mr. Al-Khatib was saying that Mr. Al-Sadiq had threatened to redeem.
yes, he had threatened to redeem at that, but he denied that at the time. But that was what he was saying. In fact, he didn't do anything about it.
Very well.
We shall have to read Mr. Black's note 105 and its various references, but the best bit I've found so far, and there may well be more,
Yeah.
is 3975
is that the red
in
flags?
the record,
Yeah.
which looks as if it must be Mr. Al-Sadiq's cross-examination. And the internal page number is, I think, 75. So it's top right-hand corner of 3.
Is it one of the one? Is it day
3975.
is it day 5, page 75, line 20 to 21?
Yeah.
Which is CRD4, tab 27.
I'm looking at.
What volume of the record are we?
I think
Be
we're in
in. You wouldn't know until
CRD.
you-
We're in CRD4. I think, though I may be wrong about this. Tab 27, page 1888.
I mean, if Mr. Sadik had been saying, I would have redeemed early, the result would have been to reduce the damages he was claiming for breach of the 45% guarantee.
Yeah, exactly. That's right.
So that's why he was so indignant at Mr. Katib's evidence.
Yeah, exactly. Exactly right. You can't have your cake and eat it. Sorry, my Lord Hughes.
Well, it was 3975. I'm sorry, because I'm doing it electronically. I don't know which bundle that.
Are you in the record? Or
It's in, I mean, the record, the one that's got 9,000 pages.
Yeah. There's something on page 73 of the mini transcript.
And at page 73 or 75, so I'm on 75.
Right.
Would you have complained, question, if the same amount of leverage had been applied through LDSF, SMF, Co and LEDF? Answer, I think I said the answer to this, but I will repeat it, that if I knew, because they had no right to put this clause in a management agreement when it's not part of the SPA, had it been suggested, even if I had a guarantee, I would have walked away from the deal because it presents a very, very high level of risk.
Yeah.
Now, whether that is anywhere near the high point, I'm not sure, but it certainly is approaching a hint that I would have walked away.
I think that is probably the high spot. All the rest of it is...
Well, 2 pages earlier, he's asked, your position has always been, I didn't care what they did with the money. Yes, I didn't care what they did with the money. I became very concerned when they reneged on the guarantee. Do we know when he's talking about that? When they reneged on the guarantee?
The point at which we make it clear, we never confirm the guarantee. There's some correspondence which is
But
slightly...
is he referring to an event which we can put a date on?
I don't think there is a particular event.
Okay.
I'm not sure.
Or simply the response to Clyde's letter?
The response to Clyde's letter in December 2009, that may be what they're referring to. I don't know.
Yes.
My Lord, it's also worth looking at his first witness statement, which is, to be fair, it's at bundle 3 of the core records, which is flag 16, paragraphs 19 and 52.
What's the page again?
1395. Sorry, it's 1348.
1348 in the core.
Exactly, yes. It's flag 15.
Paragraph?
19.
Yeah.
Yes.
And paragraph 52, which is 1362.
Sorry, paragraph?
52, my lord.
Yeah.
My lord, I'm in effect making 2 points, which is, first, his case on deceitful non-disclosure was much broader than F4, and F4 was not a freestanding claim, and most of that has now been shot away. Secondly, and separately, his case before the board was, until this morning, I want rescission ab initio, and now he's trying to put a different case. He can't complain that the judge didn't make any findings in relation to that. I accept my Lord Hughes's formulation that the judge has got to make a finding as to what would have happened, but he was never being invited to make a finding along the lines that the plaintiff now asks you to make, and the burden was upon him, not upon us. My Lord, the construction issues. First of all, this is issue number 1 in the 6 issues I'd gone through. In my respectful submission, in considering whether or not the transfer of the money to Blossom was authorised by the SPA, the question the board should ask is, was the transfer something that was, quote, for the purpose of a leveraged investment? If the board thought that it was necessary or desirable for the purpose of achieving A, then it was authorised. The answer is plainly yes, it was that. In my respectful submission, it's a red herring to go down the question, was it, quote, technically an investment? The question is, was it a necessary or desirable step for the purpose of effectuating the purpose of Clause A? And if it was, it satisfies the test. If, contrary to that view, your Lordship takes the view it is necessary to consider whether it's an investment or not, then you can conclude that it was an investment, but still be something within D2.
Are you inviting us to say it was an investment?
No,
or
I'm
are you
saying,
simply saying,
if
if perversely you were to come to that conclusion, then...
If averse to me that you were to come to the conclusion that was investment, that would not prevent it, in my view, being within D2.
You've gone to sort of no, alternatively yes, alternatively it doesn't matter.
It doesn't matter, I'd say. But if you were against me on my first case, which is an administrative case, and my second case, it doesn't matter whether it's an investment, then I would say my third case was it's an investment in a hedge fund product because its Blossom is, in effect, a facsimile of LDSF or something like it. But I say the right conclusion is the one that Miss Justice Jones and President Chadwick reached in the Court of Appeal, namely that it was an administrative step on the way to making a leveraged investment. My Lord, second question, I don't equally dissent, that's another way of putting the same case, the way that Miss Justice Jones put it, which is to say, look, if leveraging in the Blossom form is allowed, then obviously you're allowed to take what are the necessary administrative steps to get there. And if one of the necessary administrative steps was to transfer it to Blossom because you believed a clean structure was okay, then there can't be any complaint about that. And then Miss Justice Jones went on and said, well, the real question is whether you were entitled to leverage other than through a branded feeder fund. And he says, yes, you were, because the key thing was it was intended to be a leveraged investment. They were equivalent, these forms, whether it be Blossom or whether it be LDSF or SMFCO. Nobody in their right mind would think you could do one and not the other. That was effectively Mr. Justice Jones is finding. If what is called first layer leverage is allowed, then you're allowed to do a necessary step to get there. That's 4.5 in the judge's judgment. So that's my answer to issue number 1. Issue number 2, was first layer leverage allowed? Answer, yes it was, because it was economically equivalent to what had been proposed, and as the judge found, the plain effect of the agreement was to give a wide discretion to Investcorp to make decisions on the how. That is part of the factual matrix within which the contract is to be construed. In my respectful submission, if they have the power to do anything that is necessary or desirable to effectuate the purpose of what everybody agrees is a leveraged investment, in my respectful submission, it is inconceivable that they would not have had the authority to choose to do it this particular way rather than through LDSF or SMFCO. My friend, Mr. Black, accepted in answer to my Lord Briggs that they could have constructed it in such a way using first layer leverage that was absolutely identical to LDSF. So there's absolutely no commercial reason why that wouldn't have been permissible. What is the effect of I1? I1 is dealing with liquidity borrowing. That is where, separately from the fundamental of the investment, Charlotte borrows money. Either it says for liquidity purposes, for example, it has to cover a margin call pending getting money back from something, or it has to borrow money in order to meet, quote, a corporate purpose. That's the language of the document. A corporate purpose could include, for example, you've got to pay out on a hedge in relation to dirhams versus dollars, which you haven't immediately got the money from any investment to meet because the timing has gone wrong, or to pay off a director. That would be borrowing for a purpose other than the fundamental purpose of the investment. Everybody agreed that that was a different sort of investment, or borrowing to a leveraged investment. And I agree with what Mr. Black says, in effect. The fact that you mention one sort of borrowing could be an indication that they weren't intending any other. But in the context of this case, it's simply one indication that has to be weighed against the massively powerful other indications, namely, what was the essence of this transaction? The essence of this transaction was that Investcorp were being given a discretion to effect a series of leveraged investments in Investcorp's hedge funds.
But if the investment proposal had been in the minds of the draftspeople, they wouldn't have been thinking in terms of borrowing for investment by Charlotte, would they?
Well, they would have been thinking, you've got to leverage the equity that's been given. You can do it through LDSF, but there are other ways in which it can be done.
I'm looking at the investment proposal, which was investing.
No, I think I respectfully submit, they give an example, indicative terms of how it can be done, but the key thing that comes out of the investment proposal is you're going to invest in, say, DSF, and you'll leverage it 3 times. The precise method of how you do it is to be decided by Investcorp. The fact that they give as their example LDSF would not be intended or understood by the parties to mean you couldn't leverage it in another way if the position was there was another way that was recognised and accepted as being similar, which is the position here.
Could they have invested on a 3 times leveraged basis in LDSF, thereby leveraging at both levels?
I think that it would have been within their authority. A point would be reached where if it was leveraging of such an amount that was beyond the contemplation of the parties, so suppose the leveraging had been 100 times, then maybe there would have been a problem. But I doubt it, because ultimately the risk that is being taken in all of this is not losses beyond the value of the amount that's being invested. It is only the amount that's being invested that is put at risk in relation to all of that. There might be a problem of scale in relation to this, but we never reach that point here because the leveraging levels are well within that which was contemplated in the investment proposal.
Well, that's only true if if you leverage at portfolio level, you've got to liquidate before the losses exceed the initial stake.
Well, there's limited recourse. So the amount of the recourse...
You're quite right. Yes,
so none of that... sorry, I should have made this clear.
Yeah.
All of this is on the basis of limited recourse.
Yes,
so the amount that you're leveraging never puts you at risk beyond the amount of your original investment.
I had overlooked the limited recourse.
It's virtually 4 o'clock, Lord Falconer. Is this a convenient moment?
It is a convenient moment, my Lord.
I get the impression that your submissions are moving at a fairly fast pace.
My Lord,
And would I be right in thinking that you are unlikely to want to continue to address us until 20 to 1 tomorrow?
One never can tell, but I thought I might. But I mean, because I don't know the. I mean, the point that is shortened my submissions dramatically is I'm taking it that I don't need to address you on the question of deceit.
Well,
so it's an honest breach of F4.
You're taking it, Lord Falconer. I hope I made that entirely
You couldn't have made it clearer, my Lord. So yes, I don't think I will be going on to 20 to 1.
No. Right, well then that's very convenient. We meet again at 10:30.
I'm obliged.